Okay, great. So it is getting recorded now. All right. So about LeDroit, LeDroit is an online legal ed tech platform registered under Ministry of Corporate Affairs. We have been training law students and lawyers for a while now, for a period of 5 plus years, and we have trained more than 1 lakh students so far. Our main aim is to provide quality education at affordable prices. We believe that we our main aim is to bridge up the gap between law school and the real practical world, and that's our main motive. And we believe that education should be affordable for everyone. That's why we also conduct several workshops and webinars, and we also provide some free courses to help the legal fraternity. So with that aim, we have organized this today's webinar, that is on common mistakes done during contract drafting. And with that same motive, we will be learning ahead what are the common mistakes done during contract drafting. But I would like to know, like, how many of you are currently in law college, and do we have any working professionals over here? And if you're a working professional, whether you are in litigation or not. So I'll be taking out, I'll be asking questions. Just raise your hand about the same. Okay, is it fine? Um, Now another point is, like, this is a 1 hour session, and towards the end of the session, we will be sharing a feedback form. So make sure that you are attending the whole session. You are not leaving the call in between, because towards the end, we will be sharing a feedback form. Make sure that you fill that up, then only leave the session. You'll be getting your certificates based on that feedback form. So make sure that you fill that up. Okay. Are the instructions very clear? Just give a thumbs up on the same. Great. Now, I'll be asking questions like, how many of you are currently in first year or third year of your law college? I'm talking about first year or third year of 5 year course. How many of you are currently in first year or third year? Okay. Fourth and fifth year students, please raise your hand. How many of you are there from final year, fourth year, or fifth year? Do we have people who are currently working, like litigation people? Do we have anyone who is currently practicing? Please raise your hand, and others, please put your hands down. Litigation people who are currently litigating. Okay. Any corporate lawyer? Do we have anyone like who is currently working? Okay, great. Good to know you all. You can drop down your introduction in the chat box as well. So, to begin with, all LeDroit sessions are completely interactive, but considering the number of students, we have decided to keep like to interact with you via chat. But in our classes, we allow students to interact with the faculty by unmuting themselves, and you can directly ask all your queries. Okay, I'll be giving you that right as well, but in between the session. For now, let's chat with each other through messages. Okay, great. So let me just go through the messages once, and then we'll start with the session. Okay, so we have gathered for the session of common mistakes done during contract drafting. And considering that most of you are currently in law college, and I'm of the belief that you might not have drafted a contract so far. You might have attended the contract law session, like the classes, you might have attended it, but you haven't got a chance to draft the contract. Is it so? Am I right over here? Can you just drop me Okay. I don't know what's wrong with Zoom. Like, I'm the host and it's saying that host is not allowing you to unmute yourself. So I had to leave and join again. I hope I'm audible to you all. Okay, great. I'll be sharing my screen. Just let me know once it's visible to you all. Um, is it visible? Please let me know once the screen is visible. Okay. So, considering the fact that most of you all haven't drafted any contract yet, we will start with the briefs first and then we will move ahead. Okay. So, why we are here and why contract drafting is important? I'm very sure that most of you want to create your career in corporate sector. That's why you have joined the session. And some of you might have joined the session because you just want to collect the certificate. So, if you have joined the session for collecting certificate, I would really like you to change your mind towards learning, because just by collecting certificates you will not be able to gather knowledge or create a career. If you really want to create your career, focus on the learning and automatically opportunities will come to you. You don't have to just collect certificates. Okay, so we have gathered here for learning, so we'll focus on that. Now, if you want to create your career in corporate sector, one of the most essential skill you need in corporate is contract drafting. Everyone should be aware of the same. I'll be zooming on the document later on. Right now I'm not focusing on the document. Okay, so one of the most essential skill you need is contract drafting. Once you appear for the interview, the interviewer will ask you questions revolving around contract law only. So contracts is the most essential subject on which you should focus on in order to create a career in corporate sector. There are other subjects as well, such as intellectual property rights, your company law, banking law, but the major subject on which you should actually focus on right now is contract law. So when you appear for the interview, all the questions will be revolving around that. And if as a fresher you are aware of the skill of contract drafting, you will be given much more advantage. Now, how you can develop this skill? You have already done contract law during your first or second year, but the earlier you start practicing this skill, the better it will be for you, because by the time you complete your law college, you will have the skill with you in your hand. You have practiced it so far, you have done several internships, you have drafted several contracts, and you might have been started working as a freelancer. Correct. So when you start working in this manner, you will get experience of interacting with clients as well, if you started working as a freelancer during your law college. And it doesn't mean, in order to be a corporate lawyer, the best part is that you don't need to have a bar license. You can start earning earlier as well, just by like even during your college time you can start earning just by drafting contracts. So this skill is very much handy and it's very much useful throughout your career as a lawyer. Every lawyer, irrespective of their career in litigation or corporate, they should be aware of how to draft a contract, because you never know when a client can approach you requesting to draft an agreement. And if the scenario is that you are currently practicing in court, you cannot deny that you don't know how to draft a contract, because that will be expected from you. It's always better to have several clients, right? So over here you should be focusing on how to draft. Now, many people are of the belief that we can get contract formats. Like, there are several people who are selling the drafted contracts already, pre-drafted formats, and many people go for them and buy it. You can get the same formatting through Google as well. You can directly download a draft and you can edit it, but that's not how it should be. As a lawyer, you should be completely aware of how a contract is drafted. What is the step by step process to draft a contract? There are certain interviews like I had one such interview where they gave me a laptop to draft a contract from scratch. So if you start your practice by getting a pre-drafted format, you will not be having that skill to draft a contract from scratch, like drafting every word on a word file from scratch. That's why when you are right now in learning stage, it is always beneficial that you start everything from scratch. Don't rely on technology, don't rely on anyone else. You, as a lawyer, should know how to draft individually, independently, from scratch, without any support, without any help. So the aim of this webinar is to keep in like we'll be discussing things to keep in mind while drafting a contract, and how a contract is drafted. We'll be focusing on that. Okay, now we understood that why contract drafting is essential. Another importance is that drafting is the core skill that every lawyer should know, because it's your draft that reaches before you. Like, a person might may or may not meet you in person or virtually. They might not meet you in person, but they will be knowing about you through your draft. There are chances that a company has hired you to draft a contract. You might not be interacting with the company's client directly, but their client will be judging you based on the contract you have drafted. By seeing a draft, they will get to know whether the lawyer is educated, whether the lawyer is a very good lawyer, or whether the lawyer doesn't have any knowledge. So drafting becomes more of your power, it becomes your skill. So I'll be just showing you two examples. You can let me know and the difference between a lawyer who knows how to draft and a lawyer who doesn't know how to draft. I'll be sharing few examples with you. Can you see my screen over here? Okay, I believe yes. So I received this contract for review, and just by taking a quick look, it was very easy for me to understand that this contract has been drafted by ChatGPT, and that lawyer did not even take a single effort to draft this contract. So people who have experience, they easily get to know whether the contract was actually drafted, whether the lawyer actually know how to draft or not. So don't rely on ChatGPT or any other AI or any other pre-drafted contract. Drafting skill differs from person to person. You have your own unique style of drafting. So create and enhance that skill. The earlier you start, the better it will be for you. Now, I'll share another example with you and see the difference. This is another contract that has been drafted by another lawyer. Over here, you can see that how in detail everything has been mentioned. Just by looking at the contract, you are getting to know that this is a proper contract. This is an actual contract. As a person, like, let's consider that you are a client who wants to hire a lawyer. Which contract do you think like you will go for? Just by reading a contract, I'm giving you like rights to unmute yourself. Please make sure that you don't misuse it. Now you guys can answer as well. So, as a client, if I have approached you that can you just send me a sample of your contract so I can get to know like whether I want the contract to be drafted by you or not. Who do you think I'll give my work to? Do you think I'll be giving the work to the previous lawyer or to the current one? Do you think I'll be giving work to this lawyer who has drafted this contract, the one that is visible to you on screen? No, right? So that's the major difference, that people get to know whether you have that skill or not. That's why you should know how to draft a contract from scratch. Now let's see like how a contract is drafted. So now I'll be sharing another contract with you. We'll be first learning how a contract is structured, then we will be learning about how what are the things to keep in mind while drafting a contract. Okay, so I'll not be able to check the screen to see your messages. Please, any one of you can unmute and answer once the another screen is visible to you. Okay. Um, Another screen is visible to you? Yes, no. Can you see non-disclosure agreement written? Okay, thank you. Okay, so let's go with an example. We all are aware of the fact that, considering that you guys have done contract law, so still just a refresher that in order to have a contract, we need to have certain essentials of contract. First is that there should be two parties in a contract, right? And both the parties should be of mature age, that is above 18 years of age. They should be of sound mind. These are the basic essentials of contract. And in order to have any contract, we should first make an offer. That offer should be accepted. Once the offer is accepted, that offer becomes a promise. Correct? I'm just giving you a refresher. Now, that promise should be having a lawful object. The purpose for which the contract is being entered, that should be legally valid. We cannot enter into contract for a legally void contract, right? So it should be legally valid. There should be an exchange of consideration between the parties. And once all these things are covered, all the essentials of contract mentioned in the section 10 of Indian Contract Act is covered, then it becomes your valid contract. Now, can anyone just tell me under which section the contract is defined? Can anyone just tell me under which section the contract definition is covered? Section 2. Section 2, more specific about it. Correct. Section 2H. Section 2H of Indian Contract Act, year, which year? Correct, Sneha. 1872. So, under that, it is defined an agreement enforceable by law is a contract. So, with that definition, all the contracts that cover all the essentials of contract mentioned under Section 10 will be considered as a valid contract. Now, with that aim, let's go with the example that a person has approached me to draft a contract. There will be two parties, one party who like party A and party B. Let's go with party A and party B. Now we'll focus on how a contract is divided. So over here, now let's just focus on the screen. Let me just see that if I can zoom it a little bit for you. I hope it's visible to you, right? Like it's not difficult to take a look on the screen because I'm not able to see from where I can just give more focus to see. Okay, great. Okay, so a contract, this is a non disclosure agreement with me for your review. Over here, this is a already drafted contract, but of course, the name of the parties and over here in the contract, I have removed it because need to maintain confidentiality. So, this is a formatted contract. How it is divided, the first part in every contract will be the title of the contract. So over here we have the title of the contract. We will be naming like which contract this is. The reason is that we need to define that what's the purpose of contract, why we are drafting this contract. So just by reading the name non-disclosure agreement, it gives us an idea that this is a confidentiality agreement. The major purpose of this contract will be to bind the parties to maintain confidentiality, to maintain secrecy. In very simple terms, a non disclosure agreement is an agreement entered between parties to maintain confidentiality of the information shared with each other. If anyone wants me to explain things in Hindi, please let me know. I'll be comfortable with the same as well. Okay. Do we have anyone who want me to use Hindi in between? Okay. All right. So this is the title of the contract. So the first thing in every contract will be the title of it. The second part which will be following after title is the preamble of the contract. So this part over here till here will be the preamble of the contract. Okay. So under this part we are majorly going to discuss about on which date the contract is being entered and the name of the parties and the other details of the parties as well. Okay. So this part, starting from this agreement till here, will be known as the preamble of a contract, followed by from wherever in the contract you see the words whereas, this particular part will be known as your recitals. The reason they are known as recitals is that you have to recite it. So every lawyer will have their own unique language, but mostly you will find all the lawyers using the same language starting with the words whereas. So this thing you can recite it during your initial stage. When you have learned how to draft contract, you can change it based on your requirements, you can edit it. But initially it's a good practice that you start learning these words. So take a look into two or three contracts, check out their languages, how they have drafted it, and recite this particular wordings. So, and the more you practice, the better it will be for you. You will get your, like, it will be very much easier for you to easily come up with the words how to draft it. But for initial practices, I'll suggest that you start learning it, like literally recite it. That's why they are known as your recitals. Next is this part. This particular part, every contract will be for after recitals, you will be having the definition part in every contract. So over here we have the definition part. It is not clearly mentioned, the definition, but with the words like confidential and proprietary information shall mean and include any, with that you can understand that over here we have defined the term. Now, why it is essential to define anything in a contract? It is very important that you are defining words clearly in order to avoid any ambiguity of understanding, in order to avoid any confusion. That's the main reason that in every contract we have a separate definition clause where we define the words and what do we understand by the same. Okay. After definition, we will be having the main body of the contract where we are going to define the terms and conditions, that why we are actually entering into the contract. After that, so let's consider that this is the body of the contract. Thereafter we will be having boilerplate clauses. So these are again I'm not sure whether you have heard of the term boilerplate or not, but for now just understand boilerplate clauses are your umbrella clauses or already pre-structured clauses which are found in every contract. Okay. Next, we have, once the boilerplate clauses are covered, we will be having your execution clause. So over here, your wordings will be in witness whereof the parties hereto have executed this confidentiality agreement in duplicate by affixing the signature of the authorized representatives as of the date herein above mentioned. So over here, this is your execution clause. Execution clause is the clause where the parties are going to sign the contract. So after execution clause, the details of the parties, the actual representatives who are signing the contract will be mentioned. So followed by the details like signatures of the party, name of the party, and if required, the place where the contract is getting signed and the date. So the core essential things that in the execution clause which should be there will be your date, name of the party, and the signature. And also, if a person is signing on behalf of the company, it should be the designation, like the person is under which authority to sign that document. Okay. So these all things should be there in your execution clause. So once that's done, any other annexures or any other supporting documents that are needed, that will be attached below the document. So this is how your contract is structured. First part, I'll just give you a quick revision of this. First part will be your title of the contract, followed by the preamble of the contract. This particular part is your preamble. Next, we have is the recitals of the contract, followed by the definition clause. Then we will be having the boilerplate clauses of the contract, followed by the execution clause, where both the parties will be signing the contract. And if required, any other supporting agreement or exhibits that will be attached below execution clause. Is it clear? Have we got proper understanding of how a contract is structured? Great. Okay, now let's just take a look into the document of what are the mistakes. I'll be sharing the words as well. I'll be sharing one document with you. You can, like, after the session, we'll be sharing the document which I'll be sharing now. So over there you'll find all the content. Okay. Now let's see. Um, okay. Now everyone can learn how to draft. Like, whether you know or not know, by getting a pre-drafted contract you will think that you already know how to draft, but you actually don't know how to draft till the time you have actually drafted a contract, right? So there are certain things that you as a lawyer should keep in mind while drafting a contract, and how you can avoid these mistakes. Even professional lawyers who have been drafting a contract need to brush up their skills so that they can be with the times. So every person needs to brush up their skills from time to time. If you are not brushing up your skills, you will be lacking behind. Now, like, there was a time when computers were not there. We used to draft contract in hand, like, right, we used to draft it on paper. Before COVID, till that time, all the contracts used to be drafted on paper and they used to get executed in person. The virtual mode was not there. People did not used to sign the contracts virtually that much. Like, practices were there, but still it were not that trending the way they are right now. Now people mostly prefer entering into contracts virtually instead of signing them in person. Like, why to take the hassle of traveling and going and just to sign a contract when you can do it by sitting at your home, right? So nowadays we are practicing your e-contracts. Now there's another category of contract, that is your IT agreements. So there are certain lawyers who might have graduated in 2000, 2009, and so during that time the IT agreements were not that trending, but nowadays we do have a lot of IT trend. We have software companies, we have AI, we have so many things right now, right? So we need to upgrade our skills. Just by knowing how to draft a contract doesn't mean that you know everything, so you should always brush up your skills in other segments as well, because you don't know you will be getting a client from which category. If a client is, let's say, if an IT engineer approaches you to draft an IT agreement, even though you know how to draft a contract, but still you're not aware of what are the trends in IT industry, about how to draft an IT agreement, what are the things to keep in mind while drafting an IT agreement, right? You will not be aware of it. So that's why learning how to draft should not be just limited to your drafting skill, but you should be always brushing up your skills in other segments as well. There are so many other segments, like we have real estate, we have your IT, we have AI, we have other intellectual property rights, arbitration. So for each field, we have a different type of contract. Same as for each service, we have a different type of contract. A non disclosure agreement serves a completely different purpose, whereas a service agreement serves a completely different purpose, right? So, in this way, we have different segments of the contract, and we should be continuously reading and learning about new skills, new trends, so that irrespective of the scenario, we'll be able to draft a contract. Now, what are the basic things that we should always keep in mind while drafting any type of contract? We'll be going ahead with a general scenario. Like, what are the basic things that we should keep in mind? In order to draft a very good contract, we should keep like, let's go with this checklist. We should keep these following considerations while drafting it. First is ambiguous language. Now, why we are saying that we should be not making mistake of using uncertain language. The reason is the precisely or with much more clarity you draft your contract, the lesser it will be misunderstanding between the parties, right? As a lawyer, it's your role to provide a complete, clear contract. If I'm saying, like, you can take a look at the example over here. Party A will deliver the goods as soon as possible. Are you getting enough clarity over here? When I'm saying party A will deliver the goods as soon as possible, I'm lacking out on the um information, like by when the party A is required to deliver the goods, what is the deadline for the same. Okay, so In the correct example, you can see party A shall deliver the goods within 10 business days following the execution of agreement. So, by the words 10 days and 10 business days, we are getting to know how many days we have to count and how do we have to count the days, number of days. When I'm saying business days, it means your Monday to Friday. Okay, it doesn't count your Saturday or Sunday. That's why that's the major definition of your business days. So it's very important that you are very much clear with your definition. The terminology which you are using makes a lot of sense in a contract. So make sure that you are not using any words which are unclear, or try to explain in detail like what do you exactly mean. Just by saying as soon as possible, I'm not giving enough clarity to the reader. One thing while drafting a contract, keep in mind that the person who are entering into the contract are not lawyers. They are laymen. They don't have legal knowledge. They are laymen and they are trusting you. They are trusting that you are aware of how to draft a contract and you have enough knowledge about it. So they are trusting you with the language you are using in a contract. And in future, any dispute happens, anything happens, this contract will be brought into use, correct? Because this was the main proof of the communication done between the parties. Now if the contract is not very much clear, do you think the case will be in favor of your client? No, the case can go against your client because of your mistake, because you were not very much clear with your language. That's why it is always essential to make sure that you are using precise and clear language, using actual terminologies which the person can understand. So don't go with Latin phrases as well. Try to use simple English in your contracts. Clear? Just give me a second over here. Okay. Now, the next point is failure to define key terms. So, I already showed you the importance of definition clause and why do we have definition clause with us. The main purpose of having a definition clause is to clearly define what's the usage of it. What do we understand by the same? Even we are using a simple word like person. Okay, if I'm saying person, are you able to understand when I'm saying person, whom I'm actually referring to? Who do you think when I'm using the word person in a contract, we actually mean? Give me your guesses, give me your answers. When I'm using the word person, whether it involves he, she, what do you think? What comes in your mind that we are actually referring to when I'm saying the word person? Party of contract? More answers? General person? Okay. Anyone, any gender? Correct. Company firm. So in your person category, even the companies will fall under. It can refer to man, women. It can refer to a company. So all these things should be clearly explained in a definition of a contract. That even if I'm using the word person, whom I'm actually referring to, whether I'm including any company in that definition or not. Do you know companies have their own unique identity? That's why they also fall under the definition of person. Okay, that's why within the definition of person we can also count companies. Now let's go with the definition. So that's your major purpose of definition, that we need to define every word we are using in a contract in order to avoid any ambiguity, in order to avoid any confusion. Because there are chances that if for me I'm considering parties of the contract as person, but later in some clauses I have mentioned the word person, but over there I was referring to some third party or third vendors, the person who is reading the contract or signing the contract will be of some other interpretation. So, in order to avoid that confusion of interpretation and to make sure that we both are aligning on the same understanding, it is always beneficial that to include definition clause, and over there you clearly define what words you actually mean, why you're using those terms. So, let's take a look in the example. We have one incorrect clause that says absence of a definition for confidential information in a non disclosure agreement. So, why this clause is incorrect? Can anyone tell me why we are saying that this clause is incorrect? Please drop your answers. Why do you think that the said clause is incorrect? Any guesses? It is not specified. Okay, not well defined. Okay, so over here, why this particular clause is not well defined or why this is incorrect is that over here we have used the term as confidential information. Over here, we are not clearly defining that what do we actually understand by the term confidential information. So I'll just show you another example over here. Um, yeah. So we'll take a look into this clause as well. I hope you are able to see my screen now. Over here, take a look into this clause number 12, confidentiality and non-compete clause. This is a little bit much more defined clause compared to that one which we were seeing in the example, right? So over here, you have got more details, confidentiality and non-compete. No partner shall disclose company trade secrets or strategies. No partner shall operate or advise a competing business for 2 years after exit. Okay, so this is a little bit elaborative clause, right? Now let's take a look into this example. um, yeah, now take a minute and read this particular clause from scope of agreement till here. Take a look, give it a minute and read it. Just by reading it, now I'll read it for you. This agreement shall apply to all confidential and proprietary information disclosed by disclosing party to the receiving party and other information which the disclosing party identifies in writing or otherwise as confidential before or within 30 days after disclosure to the receiving party confidential information. So just by reading over here, I get to know that all the information that has been shared with the receiving party, who who is actually receiving the information is the receiving party. I'm getting to know that information will be considered as confidential information. Now, it provides much more elaborative definition of confidential information. Such confidential information consists of certain specifications, documents, software prototypes, and all technical information and all copies and derivatives containing such information that may be disclosed to the disclosing party for and during the business purpose which a party considers proprietary or confidential. Clause B says such confidential information may be in any form or medium, tangible or intangible, and may be communicated, disclosed in writing, orally, or through visual observation, or by any other means to the receiving party. So you can notice the difference. This clause focuses on everything. When I'm talking about confidential information, it is clearly providing me detail like through what means that information might have been shared with the receiving party. It's not necessary that I have shared the information with you directly, verbally. There are chances that I might have shared that information with you in writing, or I might have shared that information with you by showing you something, by not communicating with you directly, but the words through visual observation. It also covers that the information which I've showed you, I might not have communicated with you, but I've showed you a process and you learned the insights about it. That information will also be considered as confidential. So you can notice the difference, that why it is important to clearly define what you actually mean about certain terms and terminologies, right? So we got an idea that what's the importance of your definition clause and what role it plays. The next clause we have is overly complex or lengthy sentences. So when I'm saying So sorry. So when I'm saying that in order to define terms, it doesn't mean that you're overly explaining things or making it complex. Definition should also be provided to you in very simple language that is easily understandable by anyone. Don't sit with an Oxford dictionary or use the words used by ChatGPT or go with the Latin phrases, because no one is going to understand that. Even when you're using the language, we all are going to use a language that is easily understandable by everyone. If I have got a person who understands Hindi, I'm not going to share information with him in English, because that person is not going to understand it, right? He doesn't know English, so he'll not be able to interpret it. Same is with your languages. When you're using any language in contract, make sure that you are being very precise with what you actually want. If I want water, I'm not going to demand for Coke, right? Same as with your language. Don't overly explain. Don't say things that a person is not going to understand. So over here, we need to focus on the core things that actually matters in a contract. We're not going to overly explain or keep the clauses very lengthy, because if we are going to keep very lengthy clauses, there are chances we end up missing out on details. We might end up missing out on very crucial details. So that's why it is always suggested to have clear, concise language while drafting any clause. So let's take a look into this example. In the event of a breach, the party of the first part may terminate this agreement without prejudice to the other remedies. Over here, why this clause is incorrect is, let's take a look into the correct clause. If party A breaches this agreement, party B may terminate it and pursue any available legal remedies. So you can understand the wordings. The first clause is incorrect because it is unnecessarily very lengthy. It doesn't give you exact idea what you're actually talking about. Followed by the words like this agreement without prejudice to other remedies. What do you actually mean by the same? On the other hand, if I'm saying the words and pursue any available legal remedies, you are easily getting to know what the clause is actually referring to, right? So that's the major difference. Understood? Any doubts so far? Any questions? Okay. Next is omission of essential clauses. So, when drafting any contract, it is very important that we are not missing out on any major clause that is very crucial for a contract. That's why this is the place where our boilerplate clauses come into existence. So, what are boilerplate clauses? Boilerplate clauses are set of clauses which are mandatory or which are very much essential to be there in every contract. Why we are saying so? These are the set of clauses which are pre-drafted in every company to make sure that are included in all the contracts to protect the company. The major role of your boilerplate clauses are to protect the company. Okay, so they are drafted in such a manner that they are keeping the contract very much tight and significant. So, what are the things that will fall under the category of boilerplate clauses? The word boilerplate clauses is main of your, let's say, umbrella clause, under which there are several other clauses. So, under this, we will be having clauses like dispute resolution, force majeure, termination, governing law and jurisdiction, severability, entire agreement, and much more clauses. So, all these clauses will fall under the category of your boilerplate clauses. And the reason these clauses are very important is that they are very much pre drafted, keeping in mind all the scenarios, and they are included in all the contracts. So, if we miss out on any clause, such as, let's say, if we miss out on termination clause, which is very important, without mentioning about how a contract needs to be terminated, it is not always like, it is not necessary that if the parties are entering into contract, they will be doing business with each other. Let's say that the parties entered into contract for a period of 5 years. There are chances that after 5 years they will be of the view that, like, or let's say after 1 year, they are of the view that they don't want to continue. They're not liking the services, so they don't want to continue with the services, so they might decide to terminate the contract, right? So over here, termination clause will help them how to get out of the contract. That's the major role of termination clause, that it guides on what is the proper procedure from exiting from the contract. What is the legal procedure? If I cannot simply say that I don't want to do contract with you, or I no longer want your services. I cannot simply say so, or I cannot go ahead by saying that I did not like your services, so I'm not going to pay you for the same. That's not how it is. That will be considered as a breach of contract, right? So there's a proper legal procedure, and how we are going to define it, that procedure is going to be explained in your termination clause. That is the importance of that. You should, while drafting any contract, you should keep in mind that you are including all the major clauses. If you are missing out on any particular clause that is very essential, such as your termination clause, the parties will be very much confused, and later on it will create a chaos, and again the matter will be leaded to court, which might take up years to get properly done, right? So let's say nowadays party, we all know that the court proceedings take a lot of time. That's why companies nowadays go with the arbitration proceedings, so that they can get quicker resolution to their dispute. If I'm not mentioning a termination clause, it will be very much problematic for the parties to resolve the dispute. While entering the contract, the parties are of very good mood. They are very much enthusiastic while entering into contract, right? They both trust in each other. But after taking up services and after certain time, there are chances that they are not of the good mood. They no longer trust each other, and they are very much pissed off. They don't want to continue with the contract. And that scenario, they are not going to discuss with each other that how to resolve this dispute, because it may happen that the other person doesn't want to talk. So what you're going to do in that scenario, you are going to bring up the contract. That's why it is important that you should specify termination dispute resolution clauses clearly at the time of drafting the contract. In absence of these contract, the contract will become problematic and the parties will be in chaos, and again it will lead to confusion at the time of your dispute. The next point that we should keep in mind is we need to clearly specify which law will be governing a contract. Let's say that one party is from USA and the other party is from India. In that scenario, which country law will be applicable? Which court will be having jurisdiction? Law of India is completely different compared to USA, right? It is completely different. So, if both the parties are from different countries, then in that scenario, which country law will be applicable? Why this is very important to discuss at the time of entering into contract is to know that in case there is any dispute, which court will be having jurisdiction, which law will be applicable, to avoid any confusion. If I have clearly mentioned that the laws of India and the court of Delhi will be having the jurisdiction to take a look into the dispute of this contract, then at the time of dispute, automatically the case will be filed in the courts of Delhi, not anywhere else, right? So that's the major role of your governing law and jurisdiction clause, that we should clearly specify which law and which court will be having jurisdiction over the case. Any doubt so far? Are you guys able to understand? Okay, great. Next is lack of logical structuring and formatting. So, why it is important to particularly provide structuring of a contract? Anything, if I'm providing you anything without a step by step process or without a detail, if I'm asking you to um let's say if I have defined confidentiality clause first and then I am talking about boilerplate clauses, or if I'm directly showing you this document, let's go with this lecture. If I directly open this document without giving you a proper background about what a contract is, how a contract is drafted, how it is divided, would you have been able to understand what I'm talking about? Do you think so you would have been able to understand? No, because for everything we have a proper structure to make the person reading it properly understand it. There are certain formatting, right? We cannot directly jump on to eating, like getting a Maggie ready. In order to cook a Maggie, we need to cut the wrapper, we need to put the ingredients, we need to boil the water. There's a proper process of it. Same as with your contracts. Your contract should be properly structured and formatted there should be proper bullet points so that it is easily readable. There should be proper numbering, there should be heading in a contract to make it visible, to make it easily understandable and presentable. So your drafting is just not limited to drafting a contract, but also to make it presentable. Okay. Next is exclusion of boilerplate clauses. We already discussed this. That what are boilerplate clauses? Someone was requesting for the spelling of boilerplate clauses. You can take a look over here. Okay, it's the simple spelling boiler, boiler, plate, boilerplate clauses. These are also known as our umbrella clauses. Okay, lack of thorough review and proofreading. So once you have drafted the contract, don't directly send it to your client. Before sending any contract, read it multiple times, keeping in mind, let's see, like, don't read it as a lawyer. When you're proofreading a contract, consider yourself as your client and then read it. This way you will be able to understand what are the errors in the contract, what are the things that you need to keep in mind, what are the things that you need to change. You can also take help of this checklist. We will be sharing this with you. So whenever you're drafting a contract, you can take a look in the checklist as well, whether you have included all the points, whether you have clearly defined everything or not. Okay, so once you have drafted the contract, it is very essential that you proofread it multiple times in order to make sure that you have covered all the points, you're not missing out on any detail, because this is just not a contract which you are drafting for consideration. This is a contract that might be useful for the client in court of law. Okay, this will be actual proof. Next is failure to address practical business consideration. So as I mentioned, that we should always be keeping ourselves up to the society. We should be continuously brushing up our skills. So it is very important that whatever topic we are drafting on, we have proper knowledge about it. Just don't draft it. If you are drafting an IT agreement, you should be aware of the key terminologies used in IT agreement, such as your escrow, such as your SaaS, like these are the terms, these are the SaaS agreement, escrow agreement, or certain words are there which are used in IT agreements. So we should be aware of those terminologies. What is open code, what is source code, all these things. These will be used in your IT agreement, right? So without having knowledge about these things, like in our example over here, supply chain agreement, if I don't have knowledge about supply chain agreement, how I'll be able to draft it? So I should have proper background of it, why the contract is needed, what's the usage of it, and accordingly I should mention those things in the contract. So the actual purpose of the contract should also be mentioned in the contract. Okay. Next is inadequate execution and signing formalities. Again, I showed you the execution clause, how it is. So, while drafting the execution clause, we should clearly mention the details, like who are the people authorized to sign this contract, right? So, in a company, there are several people who are working. There are clerks, there are security guards, there are accountants, there are partners, right? There are multiple people who are working in a company. Now, out of them, who is the actual representative who needs to sign that contract? I cannot ask the security guard to come up and sign this agreement and make the company binding for it. There will be a proper authorized representative who has given that power to sign the contract on behalf of the company, right? So, we need to clearly specify that who are the people who will be signing that contract. That's why we need to mention the name of the parties, the designation of the parties, as well as the date on which the contract is getting signed. The date is very essential to keep record of on which date the contract got signed. Okay, so these are the basic details that you need to keep in mind while drafting an execution clause. So with that, we have covered all the points that we need to keep in mind while drafting a contract. This is the checklist. We covered that. We also discussed about how a contract is divided into several parts and everything. Any doubts, any questions? Okay, we have already started getting questions like feedback form. Yes, we'll be sharing the recording as well as this PDF with you all, so you can refer to it in future as well. We'll be sharing the feedback form again. Uh, okay. Now, if you guys Okay. If you guys enjoyed the session, I really hope that you guys got proper understanding and it was helpful for you all. It will help you in your future as well. So, really appreciate your feedback on the same. Now, we'll be having like if you want to learn more about drafting, we also have upcoming courses on contract drafting and other software contract drafting, real estate drafting, and much more. You can take a look into the same. I'll just brief you out about one course as well, because that is starting from your 24th June of this month. And in that we'll be learning the classes will be live. We'll be learning about how to draft non-disclosure agreement, franchise agreement, service agreement, master service agreement. And we'll also be sharing some tips and tricks on how to create a career in corporate, what type of questions are asked during an interview, and such things. So that is also a completely practical course, and in that you will be given assignments as well to draft a contract, and those contracts will be properly getting reviewed by us, and you'll be getting feedback on your performance, like how you have drafted it. It's a practical course. Okay. We'll be sharing the details of the course as well in the group. If you want, you can take a look into the same. And I think so the course is currently under offer price. Okay. There's just giving you a brief about one combo as well. Hold on, I'll be sharing the feedback form as well. I'm just asking the team to share the feedback form. Give it a minute. Stay on the call. So there's one more combo course, that is Ultimate Drafting Combo. In that combo, you're getting four courses, that is 10 legal drafting, real estate agreement drafting, contract drafting, and software contract drafting. This combo covers your civil, real estate, contract, and IT agreements. And this combo provides all these four courses at highly discounted price at just rupees 4,000, whereas the price for individual courses are around between 1,500 to 2,000. You can take a look into that combo as well. Okay. So, and if you wish to go with the contract drafting course, that course will be conducted by me, and it is starting from 24th June. The total duration of that course is 15 days, and the fee for that course is 1,800. Okay. Um, just give it a minute. Meanwhile, if you guys have any questions, please feel free to ask. We'll be sharing the feedback form. Just give it a minute. Okay. Guys, are you there? We'll be sharing the feedback form over here. Please make sure you fill that up and then drop the call. Okay. And we'll also be sharing a Google feedback link. Please make sure to give us a rating. We'll highly appreciate your rating on Google if you love the workshop. So I hope you are able to see the link. I've shared the link with you all. Please fill in the form and then drop the call. Okay. Great. I'm not able to pin the link, so kindly fill up the form. We'll not be sharing this link in the group, so you just have to access the feedback form link on this call and then drop the call. What will be the timing of the live session? The timing for the sessions will be same, 8:30 to 9:30 p.m. and you'll also be provided with ebooks, reading materials, as well as your recordings for future reference, and you'll also be provided with the sample drafts. So we'll be sharing proper drafts with you along with the checklist for each contract. We'll also be sharing the recordings with you, which you can refer in future, and the reading materials, and all the things will be covered from very basics, covering everything from scratch, so you have got proper understanding of the same. Okay, so that's all from my end. We'll be sharing the details of the course as well in the group, and if you have any query, feel free to reach out to the team. Yes, with regard to your certificates of this particular workshop, that will be shared after a week's time. So today is Thursday, you will be receiving your certificates by next Thursday. Once they are sent out, we'll be updating the same in the group. Okay. And the names which you'll be filling in the form, make sure that is correct. Please don't come up later on saying that the name is incorrect or anything. Make sure that you're using your right name. That's all from my end. Thank you so much for joining the session. I really hope it was helpful for you all. Thank you. Have a good night. Bye.